Well, it's a difficult question to answer. Every judgment, even if it is in a seemingly individual case, has an impact on society. Because while judges decide individual cases, the law which they lay down impacts upon society. So when we decide cases, the outcome of those cases redefines our vision of a just society for the future. Now, having said that, I may have some of my own favorites. I may be criticized for being partisan to them, but technology is very close to my heart. So one of my favorite cases is something related to technology, which was Sarvesh Mathur versus the Registrar General, where we have issued a slew of directions to the High Courts to ensure that there is a greater incorporation of technology in the working of the High Courts. For instance, we issued one direction to the effect that access to video conferencing facilities shall not be denied to any citizen or to any lawyer. So for instance, no High Court will say that only people above the age of 65 can access video conferencing, because the object of technology is to make it broad-based and inclusive. We also directed that links to the video conferencing facilities should be provided in the cause lists by various high courts. A slew of directions have been issued in Sarvesh Mathur. I've also been dealing recently about a case, the All India Judges Association case, which deals with upgrading the conditions of service of our district judiciary, which to my mind is very critical. Because it is only when we provide dignified conditions of work to our civil judges, the civil judge at the lowest level, the junior civil judges, the senior civil judges, the additional district and sessions judges, and then of course the district judges and thereafter above, that we can provide a truly responsive judiciary, attract the right kind of talent. There are some very interesting commercial cases which are not favorites, as I would say, but cases which I would like to, at least one of those cases I'd like to mention, which is the recent judgment of the 7-judge bench on whether arbitration agreements which are not stamped can be looked at when a reference is made under Section 11 for the appointment of an arbitrator. Now, that judgment has not just dealt with the narrow issue of stamping, but it has dealt with the whole arbitration universe. Or, for instance, when we laid down in a constitution bench the group of companies doctrine, that was the Cox and Kings judgment. The group of companies doctrine had to be looked at in a very nuanced perspective, pitchforking India not just as a domestic jurisdiction, but as a nation which is now increasingly looking overseas, beyond borders, as Indian business goes out and foreign business entities come in to India for the purpose of carrying on business and for promoting investment. So some of these cases in that sense, which may not exactly be the cases which the media reports, are cases which are going to reshape the future of the nation in so many which ways. And therefore, I thought I should mention some of them as well.
So now, let me ask you a very crucial question about the collegium system. People might have been asking you this time and again, but this time when Justice Kaul retired, this issue has again been raised. Do you think that this is the best system of appointment of judges that we have? Or what is your personal opinion? How can it be made more transparent, and can we have a better alternative? What is your opinion?
Well, as Chief Justice of India, I'm bound by the Constitution and I'm bound by the law which has been laid down by my own court interpreting the Constitution. And we have the collegium system for the appointment of judges, which has been now a part of our jurisprudence since 1993. And therefore, that is a system which we implement. But having said that, it is equally our duty as present members of the collegium system to make it more transparent, to make it more objective, and we have taken steps, decisive steps in that regard, which I'd like to share with you. One of the steps which we took was to ensure that all resolutions of the collegium are put on the internet, which are put on the website of the Supreme Court, so that people know the decisions that we take, and that promotes a great deal of transparency. That's one thing. Second, we have again put into the public realm the parameters which the collegium applies in the selection of judges to the Supreme Court, and so many of these parameters apply to the selection of the High Courts themselves. So those parameters, what are those parameters? First, for selection to the Supreme Court, we look at, when we draw judges to the Supreme Court from the judiciary, that is from the pool of High Court judges, we look at their seniority. Because that defines the pool of available judges who can be considered for appointment to the Supreme Court. We look at their merit. We look at integrity. That's the third important aspect. As I said, second is merit. The third is integrity. Fourth, promoting a greater sense of diversity in the Indian judiciary in terms of the recruitment of judges from diverse backgrounds, be it in terms of gender, religion, caste, marginalized backgrounds. So these are the steps which we have taken to give greater publicity to the norms which we apply. And the last but not the least, certainly, to ensure that the Supreme Court of India does give a broad sense of representation to different regions and high courts across the country. And we have put these as the basic or grounding principles on which we look at judges who are selected for appointment to the Supreme Court. I must also share with you that we have the Center for Research and Planning in the Supreme Court, and I have said this before. The Center for Research and Planning assists in compiling data about judges who are in the zone of consideration. So the leading cases which are decided by the judges, these are circulated to every member of the collegium. We do that, of course, electronically. And the Center for Research and Planning prepares a comprehensive document which is circulated to judges in the collegium. That document helps us better in evaluating the judges whose names come up for consideration and discussion among colleagues in the Supreme Court. But apart from that, every single day of our lives as judges, we are looking at the quality of the output of judges of the high courts. Because on Mondays and Fridays, when we deal with cases going up to 80 cases per bench per day, we are dealing with cases which are decided by the high courts. And those decisions give us a clear understanding of the nature of the cases which are being decided by the high courts, the complexity of the cases which are addressed by individual judges. Therefore, to say that, the collegium system is lacking in transparency would not be correct. We have taken steps to ensure that greater transparency is maintained, a sense of objectivity in the decision-making process is maintained. But I must also share something, and that's my caveat. When we consider judges for appointment to the Supreme Court, we are dealing with the careers of sitting judges of the High Court, people who are in saddle as judges of the High Court. Obviously, therefore, the deliberations which take place within the collegium can't be put out in the public realm for a variety of reasons. Many of our discussions bear on the privacy of those judges who are under consideration for appointment to the Supreme Court. Those deliberations, if they have to take place in a free and a candid atmosphere, can't be the subject matter of a video recording or a documentation. That is not the system which the Indian Constitution has adopted. The American Constitution requires confirmation of judges of the Supreme Court by the Senate. That's not the system which our Constitution adopted. And for valid reasons. The framers of the Constitution were keenly conversant with our conditions, with a multi-religious, a diverse society. And it's important that we also learn to trust our decision-making process. It's very easy to criticize the process, but now that I've been a part of the process for several years as a senior judge of the Bombay High Court, as the Chief Justice of the High Court of Judicature, Allahabad, as a puisne judge of the Supreme Court and now Chief Justice of India, I can share with you that every effort is made by our judges to ensure due consultation at the High Courts when selections are made or before recommendations are made. As you know, at the level of the High Court, judges are drawn from the district judiciary as well as from the bar. The evaluation of the judgments of the district judiciary has followed very well-established parameters. There's a judgments assessment committee in every High Court which looks at the judgments of the judges who are under the zone of consideration. They are assessed, evaluated and graded, and the output of the Judgments Assessment Committee is placed before the Collegium of the High Court when they make recommendations for appointment of district judges to the High Court. The collegiums in the High Court also look at the personnel file maintained with reference to every district judge. They look at complaints, if any, against a particular judge. They look at the entire service record, their annual confidential reports. So the process is extremely well structured, and there is a 360-degree assessment of every district judge before they are recommended for appointment. Insofar as appointments from the bar are concerned, members of the collegium rely not merely on their own knowledge of those members of the bar who practice before them, but they consult widely amongst other colleagues on the bench, because other colleagues on the bench may have specialization in a particular branch of law, which is the specialization of that particular lawyer. For instance, in the Bombay High Court, if a lawyer is from the Admiralty Bar, you would typically consult with judges who are dealing with Admiralty cases. If the lawyers are specialized in commercial law, you would consult with judges who are dealing with commercial cases. So therefore, there's a broad-based consultation. There's a great amount of consultation between the judiciary and the government itself, because after these recommendations are made by the High Court Collegium, the recommendations travel through the state government, the governor, the chief minister, thereafter to the union government. A detailed assessment is carried out by the Intelligence Bureau on the antecedents, character and integrity of each candidate. The reports of the IB are vetted by the Department of Justice in the union government. The comments of the Department of Justice are then sent to the Collegium of the Supreme Court, which reassesses the file, and the assessment is done very carefully by the three-judge collegium in the Supreme Court for the appointment of judges of the High Courts. So the process of appointment of judges in India to the High Courts is extremely well structured. It takes place at multiple levels, involving not just the High Court judges themselves, but the political arm of the government and the other agencies of the government before it comes to the Supreme Court for its final opinion. And we then make our recommendations to the Union of India for the file to be transmitted onwards to the President of India.
So you mentioned about the diversity in appointment of judges in terms of caste, class and religious minorities, etc. So have you been able to maintain that diversity in your tenure as a Chief Justice of India?
Yes, but let me not just focus on my tenure as a Chief Justice and tell you a little bit about what is happening across India. Let me begin with your question. The pool of judges available for appointment to the Supreme Court consists of people who have been appointed at least a decade earlier to the High Courts. Judges who were appointed to the High Courts a decade ago, say sometime between, I'm one of the oldest in the system, I was appointed in 2000, but judges who were appointed to the High Courts, say between 2005 and 2010, would have typically joined the bar between 1985 and 1990, or soon thereafter. So when we look at the pool which is available for appointment to the Supreme Court, that is defined in a large manner by the pool of lawyers in the 1990s. That's why it's important when we talk about the importance of, when we talk about the need to promote greater diversity in the Indian judiciary, we need to look at the pool right down to the grassroots level today. And one remarkable thing which is taking place, which is something which I must share to you as the head of the Indian judiciary, is that when we are making recruitments to the district judiciary across India, in a number of states, in a large number of states, the number of women is exceeding 50%.
In Maharashtra?
In a number of states, Rajasthan, in a number of states, the number of women who are being recruited into the Indian judiciary has crossed 60%. It's gone to 70%. That means that when you have competitive examinations and women have a level playing field, they are doing exceptionally well. Now, these women who are being recruited into the district judiciary today, 10 years or 15 years down the line, they would be the persons who would be, they would be manning positions in the High Court. And sooner or later, they would be coming into the Supreme Court eventually for appointment. The bar has to be made a far more conducive place for women to practice, and that's one of my concerns. How do we ensure a level playing field for women who are practicing? And I think there, the responsibility is not just of the judges themselves, but of members of the bar themselves. Senior members of the bar, for instance, must make sure that they make their chambers places which are accessible, which are welcoming of women. I think our chambers must factor in that women have very significantly different societal responsibilities than male lawyers have. We must factor in the fact that women have a very large role to play in terms of the work which they do for their own families, and therefore in terms of childbearing. Therefore, we must ensure that women are not put out of the profession by these challenges which womanhood brings to a member of the bar who's a woman. So I think there's a greater societal responsibility, and not just a responsibility which we place on those who are in the collegiums, but the whole structure of the bar has to undergo a change in making these spaces more welcoming of women, so as to ensure that more and more women enter the profession of the courts, lawyering within the courts, that they succeed in the process of litigation as litigation professionals, and then eventually are appointed to the high courts and then to the Supreme Court. But diversity is not a matter of only gender. And during my tenure as both a High Court judge, as the Chief Justice, and now as a judge of the Supreme Court, we've been trying our best to ensure that the Supreme Court resembles, should I say, the character of the nation, by having women judges into the Supreme Court, by bringing judges from marginalized backgrounds, by bringing in judges to the Supreme Court from diverse religious groups. Now, judges who have been appointed to the Supreme Court to bring in a great sense of diversity are not brought in because they belong to a particular religion. That's not how the process works. They've been brought in because they are among the best in the country. But while bringing in the best from the country to the Supreme Court, we also have an eye on having this broader sense of diversity in terms of gender, caste, marginalization, religion, in bringing diverse segments of our society into the Supreme Court.
Let me seek your opinion now regarding the latest judgment on Article 370, the Constitution bench judge, the judgment which came very recently. You were part of that judgment. So there has been a lot of public criticism on that judgment, especially by Justice Nariman, your former colleague and your former senior also, his father Fali Nariman. They have spoken publicly criticizing the judgment on 370. So how do you respond to that criticism, especially the issue of statehood, which they have tried to address, that the Supreme Court did not venture into that? So can you elaborate on that?
Etisham, a judge who decides a case speaks through their judgments. Once a judgment is delivered, that judgment becomes public property of the nation. Until a judgment is delivered, the process is confined to the judges who are involved in the decision of that case. Once we arrive at a decision and the judgment is pronounced, it's public property, it's the property of the nation. We are a free society. We have a constitution which protects the right to the freedom of speech and expression, and therefore people are entitled to exercise the right to freedom of speech and expression, to critique, to criticize, to appreciate. So far as we are concerned, we decide according to two parameters: the Constitution and the law. And I don't think it will be appropriate for me either to respond to criticism or to mount a defense of my judgment. What we have said in the judgment is reflected in our reasons which are contained in the signed judgment, and I must leave it at that.
As you said that judges speak through their judgment, but still I'll ask another question regarding another of your judgment regarding that same-sex marriage. It was very close to your heart also, the way I saw you dealing with this case. Do you find some kind of regret that it didn't happen the way you actually wanted it? Because you have been vociferously speaking about it since long, and it was due to a large number of LGBT community. How do you reflect to that when you look back?
The LGBTQ community has fought a long and hard battle in the realization of their rights. To a certain extent, there was a watershed in that evolution when the Supreme Court decided Navtej Johar. The recent judgment was a judgment where that community, the LGBTQ plus community, the queer community, sought a recognition of the right to marry. I'm not going to comment on the merits of the judgment for the simple reason that I want to share something with you which is very personal, and which is that over the years of training which we acquire as judges, you put everything into a case when you are deciding it. Obviously, when you are hearing a case, when you are reasoning for yourself what should be the ideal outcome of that case, when you reserve a judgment, when you are lost into your own thoughts as an individual, you're reflecting very deeply. But one thing which our training teaches us is that once you deliver a judgment in a case, you kind of distance yourself from the outcome. Outcomes are never in that sense something which are personal to a judge. You decide a case based on your vision of the Constitution, on what you believe the vision of a just society for the future is in constitutional terms, which is what I have done. I never have any regrets. Yes, I've been in a majority in many cases, I've been in a minority in any cases, but the important part about the life of a judge is never to associate yourself with the cause. Because it is only when you don't associate yourself with the cause after a judgment is delivered, that you can truly be dispassionate. Having decided a case, I leave it at that and leave it for the future of our society to judge what course the society should take.
Sir, I saw you in one of the hearings speaking on bench hunting, or some people objecting to certain cases, politically motivated, politically important cases, as they said, given to a particular judge. How do you respond to that? Is it happening, or what is behind all this, the kind of allegations which were made against the Chief Justice of India?
Well, I must tell you that there are very well defined structures and processes for the allocation of cases. First, the roster by virtue of which cases are assigned according to subject matter is printed in advance under the authority of the Chief Justice. So the roster is notified for everyone to see, and it's in the public realm. It's published on the website of the Supreme Court. Second, that's equally important, every judge of the Supreme Court is a judge of the Supreme Court. Every judge is entitled to decide any case which is assigned by the Chief Justice to them in terms of the roster. Third, and I've been a member of the bar as well, no lawyer can insist that I will have my case decided only by a particular judge, because that does not do justice either to the credibility of individual judges or to the purity of the administration of justice. Fourth, there are well-defined processes. Cases are assigned by the Chief Justice when a case comes up for assignment. For instance, if a judge recuses themselves. Normally, cases are assigned according to roster automatically by the computer. If a judge recuses, case is put up before the Chief Justice, and the Chief Justice will then reassign that case. The reassignment may be to a senior judge, it may be to a junior judge. Once the case is assigned to that judge, that case follows the judge, unless, for instance, the judge falls sick and says, well, I don't want to take up that case. I don't want to take up that case because I'm not on duty for the next month, in which case it has to be reassigned. But I'm very, very clear in my mind that if the credibility of the institution of the Supreme Court is to be maintained, we have to ensure that the allocation of cases in the Supreme Court is not going to be a lawyer-driven allocation. It has to be an allocation which we do in terms of our processes and systems which are laid down in the Supreme Court. Having said that, I can only say that, well, you have to trust your decision makers.
So one final question, again regarding one of your important judgments, that is the Ayodhya judgment. You were part of that bench. So it is very, I mean, everyone is curious to know who authored the judgment, because it happened for the first time that the judgment did not carry any name who authored the judgment. So can you now reveal what exactly was behind that and who actually authored that judgment? Many believe that it's you. Can you please elaborate to us, because the issue is now almost over and the temple is to be inaugurated this month only. So who actually authored the judgment and why it was kept secret still?
Well, when the five-judge bench sat to deliberate on the judgment, as we all do before a judgment is pronounced, we all decided unanimously that this will be a judgment of the court, and therefore there was no authorship ascribed to an individual judge. The case had a long history of conflict, of diverse viewpoints, based on the history of the nation. And all of us who were part of the bench decided that this will be a judgment of the court. The court will speak through one voice. And the idea of doing so was to send a clear message that all of us stood together, not only in the ultimate outcome, but in the reasons which were indicated in the judgment. And that was why we decided that this will read as a judgment of the court. Since we decided that this will read as a judgment of the court, it will always remain a judgment of the court, and I'll close my answer with that.
It was a pleasure talking to you, Chief Justice of India, Justice Cji Chandrachud. Thank you so much for giving your precious time and talking to us at length. And thank you so much.
Thank you very much, Etasham. It's been truly a pleasure. Thank you very much.